Martwick, Reeves Harris, to Petty.
We have 3 members answering the roll. We're going to be doing a subject matter hearing, so we don't need a quorum. And the only item we have before us this morning is House Bill 298, which is sponsored by our minority spokesperson, Representative Sandak. And so for purposes of calling up witnesses, I'm going to turn it over to Representative Sandak.
Thank you, Chair. Before we proceed, I want to kind of make a statement for the record about what the purpose of today is and what it isn't. My bill, House Bill 298, is the subject matter. But for purposes of today, what we're trying to do is offer an opportunity to educate the general public, the legislature, and interested parties about what Article 9 of the U.S. Bankruptcy Code is and what it isn't. I think there's a great deal of misapprehension and, I think, unnecessary fear over what it is. So my purpose in having today's hearing was simply to offer a forum for all those who propose this as a potential part of a process and those who oppose it to have a hearing to talk through options. Everyone's very well aware of Illinois' fiscal status right now, so too with many of its municipalities and other units of local government. Article 9, as a preface, is not a solution. It's simply a process. And it's afforded a process, I think, through 24 states in different ways, shapes, and forms. Illinois would require and necessarily need to authorize any municipality to file for Article 9 protections. This state right now does not permit that. So the purpose of today is to have an education discussion. And with that, I'm going to call up 2 panels on the proponent side and then the last panel on the opponent side. And then we'll take any questions. But for right now, Brad Ahrens from Jones Jones Day. I was getting my firms. And Bill Roberti, you want to come up? And Nancy, too, if you want to sit up at the table. Your call. Sure, absolutely. So if you wouldn't mind, obviously state your name for the record, what you do, who you work with, and then we'll get into some details about what Article 9 is and isn't. Can you push that button, Brad? There you go.
Gotcha. I'm Brad Ahrens. Last name is spelled E-R-E-N-S. I'm a partner at the law firm of Jones Day here in Chicago. I practice in the area of bankruptcy and restructuring.
Yeah, I'm Bill Roberti from Alvarez and Marsal. I am a partner at A&M. I'm managing director and a senior advisor. And for 10 years, I ran the public sector practice and worked on several municipal distress situations over the last decade.
Okay, and if you wouldn't mind, obviously, one from the angle of a practitioner practicing bankruptcy law, including Article 9, and the other from the finances perspective, particularly, I'm going to say, bondholders. Can you give us some, a 101 in what Article 9 does and doesn't do? And if you want to use, obviously, any experiences you've had, most conspicuously, I guess, Detroit is a decent, instructive example.
Right. Okay. Yes. So our firm represented the city of Detroit in its recently completed Chapter 9 proceeding. I was personally involved as well in that matter. In terms of sort of a high level...
Can you push that mic closer? I can't hear you.
Is that better? Is that better? Okay.
I'd like to add Representative Martwick to the roll. Morning.
In terms of a high-level answer in terms of what Chapter 9 does and doesn't do, I guess I'd say the following. First of all, in terms of the process, I know there's discussions of, well, can a municipality just sort of go into Chapter 9 before it's really ready, before it's really necessary? There is a gatekeeper function in Chapter 9. The analogous situations in Chapter 11, I think people have heard that term, private corporations file for Chapter 11. And a private corporation can just file, and it's in Chapter 11. By contrast, Chapter 9, a Chapter 9 entity, a municipality, has to prove to the bankruptcy court that it belongs in Chapter 9. And what that really means is it has to show it's insolvent, which is not the case in a Chapter 11. It has to show that it's not, insolvency, I should say, means it's not generally paying its debts as they come due or won't be able to pay its debts as they become due. it has to show that it either attempted to effectuate in good faith a restructuring with its creditors, or such a restructuring was impractical, usually because there's just too many creditors or there are too many inter-creditor issues, and that's otherwise operating in good faith. So I think the point there is I think there's been some concern that if municipalities are authorized to file, they might do so before they've exhausted all of their potential reasonable remedies. And Chapter 9 built into it tends to ensure that that won't happen, because if a municipality is not insolvent or hasn't met the other criteria I just mentioned, it probably won't be able to stay in Chapter 9. It'll be kicked out on an eligibility basis.
Excuse me for 1 second. I need to add Representative Breen to the roll.
So that's the front end. In terms of the back end, or what Chapter 9 really does, I think there may be some concern that Chapter 9 is what I'll call just a walk-away, meaning a municipality just walks away from its debts. I mean, that's not true in any bankruptcy matter, whether it's Chapter 11 or Chapter 9. Chapter 9 is designed to restructure debts. So creditors have claims, pension creditors have claims, funded debt creditors have claims, trade creditors have claims. Those claims have to be dealt with. They have to be dealt with fairly and cohesively, and in terms of the overall restructuring. So the end game in a Chapter 9 is for the municipality to propose a plan of adjustment, and that plan of adjustment categorizes creditors and then determines for each class of creditors what that creditor class will get in terms of recovery. So it's not zero. It could be zero, and it has been in certain cases where a municipality has no resources. But typically, creditors have recoveries. It's just a question of what those recoveries will be. And different creditors have different recoveries. Secured creditors typically get full payment. Unsecured creditors typically will get some haircut, some reduction to their claims. But what that haircut is the subject of the restructuring, the negotiations, and ultimately the court approval of the plan.
He stole my whole show. I mean, but the reality is, Brad's absolutely right. And as a financial advisor, in several of these cases, I was a financial advisor in the Detroit case, working for the European Certificate of Participation holders. I'm currently advising the secured lenders in Puerto Rico on the PREPA case. So, I think as he pointed it out accurately, that number one, you just can't file a Chapter 9. You've got to be able to prove that, in fact, you are insolvent. Nancy and I together worked on Harrisburg, and as you may or may not know, Harrisburg was dismissed because they couldn't prove insolvency. And it's also a very interesting process. And in Chapter 11, creditors can seize assets. In a Chapter 9, you can't. Basically, the city in a Chapter 9, or the municipal entity that is involved in a Chapter 9, gets to continue to run its business day to day without a lot of interference. And that's another situation that's very different than a Chapter 11. In a Chapter 11, we would go in and put in first day orders and also file, professional fees, etc. Judge doesn't get to opine early on the professional fees in a Chapter 9. Now, he approves them at the end, but it's a very, very different process. And the people in the municipal entity itself, they get to speak up, and they have their will. If they want to run their city a certain way, they're allowed to. The judge can't tell them, well, no, you can't do that. You got to do it this way. And all these cases have come out very differently. If you look at Detroit versus Stockton, which we also worked on, we represented one of the major bond insurers in Stockton, very different outcome. And in Stockton, there was a lot of discussion about the insolvency of the services, not necessarily financial insolvency, but did they have appropriate levels of service in the city to provide the day-to-day things that the city needed. And then I think, as Brad also talked about, every state's different. You've got to be able to, first of all, the state has a right to allow or not allow entities to file. So you've got to be able to, and there's some states that have no provision at all. In fact, in the primer that we provided to you as a leave behind, we show which states do and which states don't. But you know, in the case of California, there's a mediation process that has to take place first before you ever get into the fact of the actual Chapter 9 and what the judges can and cannot do. And that's a fairly lengthy process by itself. So, you know, I don't consider Chapter 9 to be a good thing or a bad thing. Sometimes it's a necessary thing depending on the actual financial state of the entity that you're looking at. And, you know, when I was in New Orleans, Louisiana, post-Katrina, and I ran the New Orleans public school system for 2.5 years, at one point I had to think about whether or not I was going to file the Orleans Parish school system. And I remember having a meeting with Treasurer John Kennedy, and John was like, "You can't do this, Bill. I'm not going to let you do it because you're going to destroy the credit rating of the state of Louisiana." And we were able to figure out a way not to do it and to allow that entity to continue on and satisfy all its obligations. But again, there's a process and there's authority levels that have to come down and allow you to do what you're going to do. You just can't go do it. So, I mean, those are my opening comments.
Would the speakers kind of look? The term bankruptcy conjures up images in people's minds, and I heard from people with respect to my bill that this would adjudicating a town as a bankrupt. The stigma associated with that is not something that's a good thing. As a former mayor, I can tell you, and I know we have a mayor that will be speaking later on. I don't think there's any mayor or any other leader of a local unit of government that wants to be the person that brings their town into bankruptcy. That's not a badge of honor. It's a note of last. I mean, it's the measure of last resort. But could you compare and contrast, because people they have images of late night TV, bankruptcy attorneys, and or kind of debt consolidation images. Differentiate Chapter 7s and 11s versus 9s at a remedial level, what the distinctions are and what the end game ultimately is with respect to 7s and 11s versus 9s.
Okay. Let me do that, and then let me give one observation or two from Detroit that I think relates to what we're talking about that I think will also be helpful. So Chapter 7 of the Bankruptcy Code, and again, Bankruptcy Code is a federal piece of legislation, so all the bankruptcy laws are federal laws. Chapter 7 is really for liquidation. So a company is liquidated or an individual turns over all of its assets effectively. Chapter 11 is a reorganization statute. A company reorganizes. Typically, the old owners lose their ownership in the company. The creditors become the new owners and get various other recoveries. So
I hate to do this to you one more time. I'm going to add Representative Petty to the roll.
Chapter 9 is most analogous, I suppose, to Chapter 11 because it's also a reorganization. You don't liquidate a city, obviously. You don't sell even its assets, but you certainly don't close the whole city. The difference between Chapter 9 and 11 there, though, is there's no shareholder of a city. So the shareholder aspect of Chapter 11 doesn't exist in Chapter 9. And as a result, it's not that the creditors become owners of the city. Instead, the creditors effectively take whatever value exists for distribution to creditors and no more. The observation I want to make, and then I'll let Bill respond as well, on Detroit, because we went through that proceeding for the city that I think would be helpful, is Detroit was in a very bad situation and really could not adequately provide services to its citizens. And there was a term coined during the proceeding called service delivery insolvency. So Detroit maybe is a special case, but it was so bad, and you probably heard stories that there wasn't adequate police to really respond to calls in a reasonable period of time. The transportation system was broken down and the like. What the reorganization allowed the city to do by freeing up resources was to invest somewhere over the next 10 years of $1 billion, I think, to $1.5 billion that just didn't otherwise exist. So if Detroit had not filed, I think it would have just gone. I'm not sure how it would have paid its bills, but clearly it would have gone along on a process where the services to its citizens were not even remotely adequate. So that was one big advantage to the outcome of the proceeding. The other thing, which I think goes to what was raised, which is this idea that if a city files for bankruptcy, it will destroy not only its own credit rating, but also other credit ratings in the same state. Look, I can't speak to that. I don't know if there's proof of that or not proof of that, but I can tell you one thing in Detroit. So we did 3 financings in Detroit, and I was personally involved in all of them. We did what's called debtor in possession financing, which was fairly unique at the front end of the case. We did exit financing on the back end of the case, which is providing new financing to the city as part of its reorganization plan. And then we did sort of a tender offer for water and sewer bonds. And I can tell you in each of those situations, creditors were clamoring to get into the deal. So on the DIP financing, for instance, it's sort of interesting. I won't make this a long story, but we had sort of a dispute with the judge. The underwriter for our financing had some discretion as to how to price the debt, how much the interest rate was going to be based on, the demand for the debt. And we wanted that piece of information sealed from the public, because if the public, meaning the people who might buy the debt, knew the underwriter could take the interest rate up to a certain amount, presumably they would say, yeah, give me the highest interest rate. But the judge wouldn't let us seal. So the entire market knew kind of limit of what the city would agree to pay. And yet there was so much demand for the debt that we wound up paying the lowest amount. Similar situation happened on the exit financing. It was oversubscribed. So, every deal's different. Depends on the collateral you're offering, the interest rate you're offering. But we did not find at all, as to Detroit, much less the other towns and municipalities in Michigan, that there was creditor aversion to buying our securities.
I think it's a good point, but we also have to look at the fact that our financial markets in this country have changed dramatically in the last 20 years. I mean, hedge funds were certainly part of what happened in Detroit, and they're not quite as risk averse as typical banks, let's say. So I agree with all of what Brad had to say. And again, when you look at the outcomes of these situations, they're very different. And again, like if I talk about Stockton, for example, in that particular situation, all but one creditor who's continuing to fight the Stockton bankruptcy came out pretty well. I mean, the creditor that we were representing came out, if you look at it, not on a present value basis, they were going to get 100% paid back. It was going to take them longer to get paid back, but they get 100% of their money. On a present value basis, if everything worked and all the mechanisms that were put in place to continue to make those payments to them, they were going to be about 85% whole on a present value basis. So, and another interesting part of the Detroit case, and I'm sure Brad will remember this, there was quite a bit of assets in the city of Detroit. And there was a lot of conversation and discussion around two major issues: the property and the artwork that was actually in the Detroit Museum. And quite honestly, there were a lot of creditors that wanted to go after both of those assets aggressively. And quite honestly, in a Chapter 9, they were not allowed to. And there was a deal cut with the state and the city where those assets were preserved, and certainly the art was, and because that was there for the common good of the people of Detroit. And that was part of the city, and those assets weren't going to be sold off to pay off the debt. So again, that's part of Chapter 9, very different than an 11, where those assets would have been, given up and disposed of to the creditors.
Both gentlemen alluded, Bill, you and your anecdotal New Orleans example, and Brad, just with respect to Detroit, there's been some colloquy about collateral damage to other municipalities' creditworthiness in the Detroit experience. Other municipalities supposedly, I don't know this, I've been hearing it, have suffered credit-related issues, meaning they're paying more to get money, to borrow money. In Mr. Spiato's handout, he talks about statutory lien rights, which I think were afforded in Connecticut, if I'm not mistaken. Mm-hmm. What does a statutory lien right for general obligation municipal bondholders, what does that bring to the table in an Chapter 9 proceeding, as far as you're concerned?
Okay. So, yes, if there is legislation in a state which provides that general obligation bondholders get the benefit of a statutory lien, it could be a lien on tax revenue, it could be a lien on properties, it could be a lien on, frankly, anything. But if that's put in place prior to the bankruptcy, then those general obligation bondholders come into the bankruptcy as fully secured creditors, not only with respect to assets that existed at the time of the filing, but assets that arise after the filing. So assuming the collateral is sufficient to cover their debt, they're protected in the bankruptcy. They should be paid 100 cent dollars, and as a result, they will be unimpaired in a general sense. So the recoveries will be in full. Absent that statutory lien, if they're just general unsecured creditors, and they may or may not be, in the absence of a statutory lien, they may have a contractual lien. But if they're just general unsecured creditors, then they, like all the other general unsecured creditors in the case, as I mentioned before, will get whatever recoveries are available. In some cases, 100% recoveries have been available. In other cases, there's a discount depending on what the resources of the municipality are.
Again, absolutely right. I mean, the recoveries are different. And if you do what Brad suggested on the statutory lien, and you basically become like a secured lender, and then you're entitled to 100% of your money back. But the problem is going to be, how big's the pie? and if you do that, and all those people are 100% protected, then where's the adjustment come from? So you got to kind of think about all of that as you think through these pieces of what you're going to do.
Last piece, and then obviously, Madam Chair, any questions anyone else has? Can you speak to impairment? It was your word, Brad. I think that's a bankruptcy term of art as well. Yeah. With respect to ongoing executory contracts and pension obligations. Mm-hmm. In your experience, whether it's Detroit or in other Chapter 9 proceedings, where do the instance of ongoing contracts come into play, and then any potential impairment of pension obligations to retirees?
Okay. Well, again, every case is different. We'll keep repeating that theme. Detroit, I can give you a couple responses. Executory contracts in bankruptcy are treated as follows, which is the municipality or the debtor has to decide whether it wants to keep that contract or reject is the term of art, meaning get rid of that contract. If contracts are kept, then all obligations on the contract have to be paid. So it's treated like a fully secured creditor, for lack of a better word, full payment. If the contract's rejected, then typically the contract party has a claim in the bankruptcy, which is typically unsecured. So that's how it would be treated. With respect to pension claims are typically unsecured claims, although the amount of the unsecured claim is usually the deficiency, if there is one, between the actuarial value of the claim and the actual value of the assets that sit in the pension plan. So the difference is the unsecured claim. And again, in different situations, those claims have been treated differently. In some cases, they've gotten 100% recoveries. In some cases, they've gotten less than 100% recoveries. It depends on the resources, the negotiations. In Detroit, I don't remember the exact numbers, but the pension claims did not get 100% recoveries, although some of the other creditors were claiming that the pension creditors did get actually 100% or maybe even more than 100% recovery, because one challenge you have in this set of issues with respect to things like pensions is the recovery is based on actuarial estimates of recoveries on the invested assets over many, many years, the actual value of the claim. So there's all this, sort of data that goes into it, as opposed to saying, well, you have a $100 million note. I mean, that's a $100 million claim. It's very clear. So experts can come in and assert different values, different discount rates to drive different recoveries. So there's typically disputes as to what creditors are actually getting in those scenarios. Again, the pension claimants asserted that they were not getting 100% recoveries. Other creditors asserted that Detroit pension creditors were getting 100% recoveries. The truth is probably somewhere in between.
This is an interesting topic. If you look at the 8 cases that have, in the last 10 years, in the case of Central Falls, Rhode Island, pensioners were impaired in that particular case. If you look at Stockton, because of CalPERS, even though Judge Klein wanted to and talked about impairing CalPERS, he didn't. So, but retirees did lose health care benefits and some other things, and they ended up having to where they were getting it for free. They now have to pay a monthly stipend for their health care. So, as Brad points out, in every case it's different. And you look at San Bernardino, which is still in bankruptcy right now, and this is part of the big fight that's going on there. And again, CalPERS is a fairly large gorilla in the room. So, it's going to be hard to fight CalPERS, and to date, in most cases, they've been made whole. So it really depends in each case.
I'm going to go to Representative Anderson and then Representative Martwick.
Thank you. Good morning. Where to begin? I think I'd like to focus a few questions and have you speak to us a little bit about non-general obligation debt. You talked about the pie, and what has to be divided up, but municipalities have lots of different pies, if you will. So I'm thinking about a couple of different categories that I'd ask you to speak to. One is those dollars that municipalities receive from a state that are specifically designed for one thing only. The one I immediately think of is MFT dollars, motor fuel tax dollars. How, if at all, are those affected? So that would be, I'm going to give you 3 scenarios and maybe you can deal with each. So that's one category. In other words, are those impaired or how are they affected in the contracts that relate to those? Number 2 are what I would characterize as leverage dollars. In other words, those contracts where it's general obligation money, if you will, that's being used by the municipality, but they're pairing that money with either federal or state dollars. So those dollars, those contracts in prioritization, if you will, are higher value than they might initially appear. How does a bankruptcy court take that into account in determining what gets rejected, what gets retained, so to speak? And then the third is TIF districts, business districts, either where they are bonded or those where they're pay as you go. In each case, there's an agreement with developers or landowners that say, we will reimburse for X, Y, or Z improvement costs. Sometimes, as I said, they're bonded, but oftentimes they're not. Will this affect those projects and agreements, since that's specifically not GO debt? So those are kind of the categories I'd like you to speak to, if you could.
Okay. Here's what I'd say in general. This set of issues, and there's some commonality from a legal perspective, is a complicated analysis. And these issues did come up in Detroit, and I think do come up in other cases. And I don't think the law is actually sufficiently developed for there to be clear answers. So, for instance, the issue of whether, if there's money coming into a municipality like federal grants, whether that money can only be used for the purpose of the grant, or the municipality can say, great, I've got this $5 million, I'm just going to use it kind of for whatever. That issue hasn't typically come up in the courts, but I think most people believe, and I would say I would be in this camp generally as well, that it is likely the municipality has to use the money for its intended purpose. Okay, but there are different flavors of this, and so that general rule may not always apply in every case. I can tell you in Detroit, for instance, there was something like $500 or $600 million sitting in the water and sewer fund. And so the general creditor said, well, why don't we just grab that money? What's the big deal? And then you don't need to, we can dismiss the bankruptcy and you've got, lots of money to operate. And so there was a little bit of litigation on that, but the general thinking was, wait a second, the water and sewer system was a closed system. The money in that system was not supposed to leave the system, and the city couldn't just take out of one pocket and put it in another. But that's the kind of issue you face. So I think I can only answer your question generally, which is, in general, I think money that comes in from third parties, from grants or other programs, is probably going to be kept in for the purpose it was intended. With respect to TIF districts, I'm not sure I fully understood the question, but if the question is, for instance, is the developer going to fully recover the reimbursement it was promised by a state or municipality, I think the answer is maybe, maybe not, because that may be in the nature of an executory contract. And so if the municipality felt that it wasn't a good deal anymore, it could potentially reject that contract, and the developer could be out that money. It would have a claim in the case. Again, bankruptcy is never a walkaway. If your rights are impaired, you have a claim for your state law rights, but you may not get 100% dollars. So it may be the developer would have a claim for the reimbursement and might not get it in full.
Is there any distinction between GO debt and non-GO debt for these purposes? Because when I've done TIF deals, TIF projects, the reliance I know of the developers is that this is backed up either by the bonds or by the TIF income, the increment that's generated, and the reliance is that it's really almost a separate district, if you will, from the community. It's not, but for purposes of the funding and the financial analysis, it generally is viewed as pretty distinct.
Here's what I'd say, and this came up in litigation in Detroit with respect to like unlimited tax obligation bonds. Bankruptcy tends to be sort of simple. Either you're a secured creditor or you're an unsecured creditor. And in the litigation I mentioned, people were claiming, well, maybe there's these different middle categories, and that's not really how the bankruptcy laws work. You're either unsecured or you're secured. So when we talked about statutory liens before, that creditor would be secured. If you don't have a true clear lien, you're going to be unsecured, and all unsecured creditors are generally treated equally or close to equally, which again is they get whatever recoveries the municipalities' resources allow.
Okay, thank you. That actually brings up another question then. Is our option in creating this option for municipalities to be able to file under Chapter 9, is it a toggle switch, if you will? Either we say yes and then the federal laws take over and govern, or do we have any ability to deal with any of these questions in our statutes?
Make sure I understand your question. So there's different flavors of enabling legislation, I guess is what I'll put it. So some states authorize their municipalities to file for bankruptcy. That's effectively what's being proposed. Other states have no legislation, and so it's unclear, but the presumption is then the municipalities can't file. Some states actually, I think, do have legislation specifically prohibiting the municipalities from filing, then that's clear. And then some states have a little bit of a middle ground, which is they will allow their municipalities to file, but there are what may be called gatekeeper functions. Maybe the governor has to sign off. Maybe somebody else in the state government has to sign off. Michigan, as I think everybody is aware, had a much more complicated statute involving an emergency manager and various processes. In California, which Bill knows better than I do, has a similarly complicated statutory scheme.
Yeah, California's got, again, a mediation clause built into theirs. So if you're going to do this, you've got to go through this process. In the state of Pennsylvania, it's Act 47. You can't file unless you go through Act 47 first, which is a process that they put you through to see if, in fact, you can almost do what I would call an out-of-court. In other words, right the ship so that you don't have to go down that road. And again, yes, the governor then ultimately has to sign off on whether or not he allows you to do it or not. And Michigan, as we pointed out, has the emergency, manager law. So, I mean, every state, again, is very different on how this is approached. And I basically concur with all of his comments about the way all these different funds are handled. Like, for example, in Stockton, we had 166 different accounts in the city of Stockton where money was kept. Mm-hmm. Okay, and in the case of federal funds, I will tell you, because I'm the third-party fiduciary over all the federal money that goes into the Commonwealth of Guam for the U.S. Department of Ed, you spend the money the way you're supposed to spend it. Right. And if you don't, they'll shut you off. And, that was why I got hired in New Orleans to begin with, because there was $71 million worth of federal money missing in the Orleans Parish school system. Mm-hmm. So federal, you can't fool around with federal money. Federal money, and there's rules and laws that say how that money needs to get spent. You have to follow those rules and those laws. Now, I will tell you that there's room inside these different funds to move the money around. I mean, like, for example, you can, in fact, borrow money from one fund to, if you're short in this fund, but then there's rules that say you've got to pay it back in a certain period of time. So you've got to, the books have to be right at the end of the year when you finalize your CAFR.
Great. And one oh, I'm sorry.
I was going to say, this is in Mr. Spio's material, so you can look at it at your leisure, but just to give you some data on the enabling legislation. So roughly about half the states authorize filing, the other half are silent. And of the half that authorize filing, again, about half are just pure, municipalities can file. And then the other half have some type of, again, gatekeeper or contingency aspect to it, so a municipality can't file with us without some other authorization. That's kind of how the states break out.
Thank you. Very, very excellent answers. Speak to me a little bit more about one aspect. You talked about the art collection in Detroit, and I'm very interested in that because there's a lot of assets there, but it's a very subjective thing, if you will, art. How is a decision like that made? In other words, are there standards for making that determination? And if there are, how does that work?
Well, again, as we said before, the creditors in a case like very different. You're not, the assets aren't up for sale. Creditors just can't seize the assets. They can't come in and seize the art. They can't come in and seize the monorail. They can't take it over. And even if it's an asset, they can't, because it's there for the enjoyment or the use of the city.
Period, the end, or is there potential that a court could say, yes, we're going to sell the Monets?
The Chapter 9 laws are pretty clear, and I'll let the lawyers speak to that, but my answer is probably, we tried. And believe me, I was on the creditor side. We tried.
Mm-hmm.
Well, okay. So the art in Detroit was complicated by at least one thing, which is it wasn't clear as the city's art to begin with. So there was a legal dispute that sat behind all of these issues. But in terms of what we're discussing here, we actually did get rulings on this. The judge at the hearing on approving the plan said very clearly that he could not force the city to sell the art or otherwise provide it to creditors. However, having said that, at the end of the day, a bankruptcy judge approving a plan of adjustment has to conclude that the overall plan is sort of fair and equitable and makes sense. Right. And so the judge can always say, look, I can't force you to provide value from the art or other assets to creditors, but if you don't, I'm not going to approve your plan. So there is always the ability for the judge to push the municipality to provide more resources to creditors if the judge thinks that's necessary and appropriate.
Thank you very much. Appreciate the answers.
Representative Martwick.
Thank you, Madam Chairman, and thank you, lady and gentlemen, for coming here today. I have a couple questions just from what I heard. I want to just go back to the gatekeeper provisions. Those I find rather interesting that you talked about. Can you opine on the effectiveness of these? As I was listening, and I probably have the least experience in bankruptcy law here of anyone in the room, so forgive me for no. Okay, I'm joined by a couple of my colleagues, I see. So much of it is foreign to me, but as I listen to it, I think about how we apply bankruptcy to democracy. Right? Democracy is by the people, for the people, making decisions. Not that those decisions are always good, but that's democracy, right? And in this case, in some instances, we've replaced democracy in bankruptcy proceedings with a judge who makes decisions. Obviously, it's a legal proceeding, and it's all part of it's part of our democracy, but we're almost substituting out the government for that decision-making process because we've decided they're not making good decisions. So I'm curious about those gatekeeper provisions. Without a gatekeeper provision, from the standpoint of democracy, it would sound like the government that's in control has the full decision-making, right? With the gatekeeper provision, it sounds like the government that's in control, the one that is the debtor in this instance, now has to seek approval from another government that's not responsible. Right, not in control. So a governor signing off, that could be and I'm just wondering, with your experience, how that works. I would think with changes in politics, there might be one governor who is happy to sign off on these things, and there could be an election, and suddenly the governor says, nope, nobody's going to bankruptcy. So can you just opine just your experience and how these different gatekeeper provisions work, and if you have maybe a suggestion, if you were to create one, what would be the ideal one?
Okay. Well, again, there's a continuum. Some statutes simply say a municipality and the state can file, but the governor just has to sign off. And sometimes that's just sort of pro forma. Sometimes it's not. If you think about it, most municipal bankruptcy filings are actually by very small municipalities or irrigation districts and the like. So one of the things to think about is, those kinds of entities have very scarce resources. And so states might say, these small cities and the like, they may not kind of really know what they're doing. They may not have enough resources to do enough analysis. So we want someone at the state level, and the state has much more in the way of resources, take a look at this before it happens. So that gatekeeper function may make more sense there than in bigger cities, which have, much more resources, much more professional management, much more access to advisors. The other end of the spectrum is probably what exists, again, in California or Michigan, where there's a very complicated process to ultimately have the municipality file for bankruptcy. It has to go through a number of different hoops. That may or may not make sense depending on the situation. It can create a lot of bureaucracy. It can create a lot of delay. It can create a lot of cost. that may not be necessary, because at the end of the day, you wind up in the same situation, which is the municipality files for Chapter 9. The one thing about the Michigan statute, again, that is different, and we're aware of because it led to the Detroit filing, is it had a procedure. This didn't have to be the way it went, but it is the way it went, where was the so-called emergency manager was put in place. And to your issue of democracy, that is a change. So that meant effectively that all the powers of the city council and the mayor were rolled up into one person, the emergency manager, and that one person, like the CEO of a company, was able to make all decisions for the municipality, including putting the municipality into Chapter 11, again, with the consent of the governor. But other statutes just want a sign-off by the state, for instance, and that's not really a matter of democracy. That's just a check at the state level. And going into the bankruptcy, it would still be the mayor and the city council and the like that would run the process and make decisions during the bankruptcy.
Thank you. The next question I have is would be regarding the pensions. You had mentioned that. Correct me if I'm wrong. I'm absorbing a lot here. They value the assets of the plan, and then they actuarially value the liabilities of the plan, and the difference is the unsecured debt. Is that correct?
Correct.
So I'm going to use an example just that I'm aware of, and probably because I see some representatives from the Chicago firefighters. I don't know if they'll be here to testify or not. And I don't know that there are any other pension plans in the state of Illinois that are as woefully funded as that fund. But that fund, last time I had a meeting with them, I thought it was just under 5 years or under 6 years maybe from a zero balance. So my guess is that the unfunded liability in that fund is probably enormous, right? Now, I don't know that the city of Chicago is ready for that, but I just want to. So that would mean that in that instance where there are almost no assets to the fund, and they're draining out really fast because they're using assets to pay off the current obligations. So then the unsecured debt in that fund would be most of it. Is that correct?
Yes, if you had a very low level of funding, then most of the liability would be the claim in the case.
So you had mentioned that each case with pensions are different, but is it more likely that funds with a huge unsecured liability or debt or whatever to claim are they the ones that are more likely to be reduced if that goes to a municipal bankruptcy?
It's really up to the judge.
Totally up to the judge.
It's up to the judge. In this case, it's up to the judge.
Okay.
Whether he's going to impair them or not. And he's got, as far as I know, he's got full purview over that. But at the end of the day, if you're going to continue to make those payments in the pie from that entity, where's the money going to come from?
Right. Well, and so that would be my next question. What authority, when a municipality enters into bankruptcy proceedings, obviously this is a writing of the books, right? Is that an easy way of putting it? Clearing of the books, whatever, right? Balancing the books through any method possible. But does the bankruptcy proceeding ever include a look at taxation, at revenues? Does the bank never? So whatever the current revenue are, that's what they stay.
No, again, that's the will of the people. That's, you want to raise your taxes, you'll vote on it, and you'll raise your taxes. But
right.
The judge isn't going to tell you to raise your taxes.
So the judge comes in and takes a look at the financial picture on the day, and if in his determination he has almost, like you said, that ultimate authority to make decisions regarding obligations to employees, but he has no authority whatsoever to say, well, gee, your revenues are exceptionally low. We could raise revenue and right this ship that way.
Well, no, but what's going to happen is, in fact, in San Bernardino's being protracted out, the judge is not ruling on it because he's got a rule on a plan of adjustment. And what he's going to rule on in the end is the fact that he believes that the plan is in fact a good plan and that this city is going to be able to go forward. If he doesn't believe that, he can't take him out of bankruptcy, I think.
Right. It's very similar to what we said in terms of the art. So again, the judge couldn't force the city of Detroit to sell the art, but might conclude that he wasn't going to approve the plan unless they provide some value to account for it. Same thing on taxes. Now in Detroit, we didn't really have that issue because Detroit was at its statutory maximums in terms of taxation. It already had the highest property taxes in the country, so there was no idea that it could really raise taxes further. But if you're in a different situation, the judge can say, you know what, I've got testimony that shows there's room to raise taxes in this municipality, not to make it like the highest in the country, but to make it sort of market or whatever.
Right.
And if that's not part of the program, then I'm not sure I'm going to approve the plan of adjustment.
Very good.
I think the reality is, again, companies don't rush into Chapter 11. Municipalities also don't rush into Chapter 9.
No.
You're probably not going to face too many situations where a municipality hasn't explored tax increases, at least reasonably, before going into Chapter 9.
And one last question, and I don't know if this may have been answered as you saw, I was a little bit late in arriving this morning. When a municipality makes the decision to enter into Chapter 9, that's for the entire financial picture, all of their financial doings. Can they separate out and say, well, can they separate out their finances and say, well, this part of what we do is running just fine, but this part is really in trouble, so we'd like to claim 9 on this? It's the whole thing, or it's nothing?
It's a municipal subdivision. So if you're going to file the municipal subdivision, you're filing a municipal subdivision. I mean, municipal subdivision could be a school system. Doesn't necessarily have to be a city. Could be a sewer and water board. You know, it doesn't necessarily. Again, when we talk about municipal, we're talking about a municipal entity. It's the entity itself. And but you can't say, if you've got this entity, well, this part of the entity is okay, but this part of the entity is not okay. I mean, you know, it's one entity.
Right. I'm just curious about the.
Yeah. No, but it does create complications. Like in a corporate setting, you have, you know, a parent company, you might have subsidiaries, and, you know, they're all distinct legal entities. It's very clear, and you could put which ones in you think is appropriate. In municipal space, it can be a little different. So in Detroit, for instance, the court system was a separate legal entity from the state, or excuse me, from the city. So when the city filed, the court system was not in bankruptcy, but really the court system got most of its funding, or maybe all of its funding, from the city. So it was complicated because it wasn't in bankruptcy, but its debts also had to be adjusted. Right. Otherwise, they were just going to fall back on the city. So
Right.
you do create those kinds of situations. The water and sewer system was legally part of the city, so it was in bankruptcy.
Right. And again, please don't read into my comments, because I think the city of Chicago is doing quite well. But I'm just curious, like, could the city, which, you know, there's a large pension obligation for an unfunded liability for the Chicago teachers' pension plan, and CPS is technically, I mean, it's got its own taxation and all of that, although the school board is wholly appointed by the mayor of the city of Chicago. So could that be separated out and say, let's file bankruptcy on CPS but not in the city of Chicago? Yes, it could.
I think it could.
Okay.
I think it could. I mean, I don't know how it's formed, but in my mind, if it's got its own funding, its own bonding authority, and it's considered a municipal entity, then yes, the answer is yes, I believe.
Yeah, again, I don't know the specifics in Chicago. Either they're distinct legal entities or not. If they are, then yes, you can file a separate entity. If they're not, if they're the same legal entity, then it's either all in or not all in.
Just like in Detroit, we could have filed the Detroit public school system and not affected the city. And that was before the city of Detroit actually filed. So, yes, I believe so. Again, looking at the entity itself and understanding the way it's structured, but I believe so.
Very good. Thank you very much for attending here and educating us on these matters. It's appreciated. Thank you.
So I know about as much about bankruptcy as does Representative Martwick, so I apologize if my questions are sort of basic. Can you describe for me a little bit more what it means to be a secured versus an unsecured creditor for a municipality? Is that a general obligation bond? Is it what is it?
Okay, so whether you are as a creditor secured or unsecured is a matter of state law. To be a secured creditor means the issuer, in this case the municipality, has given you either the municipality is giving you a contractual lien, so when it did its debt deal with you, it granted under contract a lien on its assets, or there are statutes that just provide creditors of that type have a lien, again, on the municipality's revenue, taxes, assets, and the like. So in bankruptcy, if you are a secured creditor, there's lots of rights that you get, but the ultimate right you get is full payment to the extent of the value of your collateral.
Yeah.
So if you had a claim of, let's say, $100 million and you only had collateral that's worth $20 million, you're only secured to 20, and then the 80 million would be an unsecured claim. But if your collateral is worth the amount of your debt, then you're fully secured, and you will get paid 100 cent dollars during the bankruptcy. You also may get interest during the bankruptcy, which otherwise stops for all other creditors. If you're unsecured, it just means you lack security. You have no contractual or statutory lien or security interest.
Can you give me an example of a contractual lien?
Contractual lien, like, for instance, this is kind of a stupid example, but you buy a house, right? You get a mortgage. You get
no, but in the government situation, I'm struggling with what asset does government give you a security interest in that isn't a public asset, like a
Taxes.
a monorail or.
Well, it really could be any asset. So yes, as Bill's saying, it's often typical just to grant a lien in cash flow and tax revenue and the like.
Okay.
But a municipality can also grant a lien in, subject to state law, a physical plant, sort of an actual tangible asset. The problem is, compared to the private sector, where if there's a default, the secured creditor can go foreclose and liquidate and sell that asset. That's typically not the case in municipalities.
So, for example, in Puerto Rico right now, Puerto Rico issues bonds, a lot of different types of bonds, and they have $73 billion worth of debt in that Commonwealth. But some of those bonds are issued as what they call COFINA bonds. So they're backed up by the good faith and credit of the taxes that are collected in the COFINA. So in effect, those bonds are 100% secured by the COFINA. And as long as the COFINA is worth what the bonds are valued at, then they have 100% secured.
So if a bond is backed up by the full, let's take a state of Illinois, for example. If a bond is backed by the full faith and credit, specifically those words, then that's
Well,
is that
again, it's got to
secured?
be a specific stream of cash, or it's got to be an asset. It's got to be something tangible.
But so it does have to. So would a basic revenue bond that's backed up by a source of revenue, that's an example of a secured.
Exactly.
But a general obligation bond would not be secured, basically.
Yeah, so this came up in Detroit. So there were general obligation bonds, and the way those bonds read were they were secured, sometimes it actually said that, secured by the full faith and credit of the municipality. So the creditor said, well, we're secured. And the response was, you're not secured by anything tangible. There's no tax revenue, there's no asset. The full faith and credit is not an asset. It's just really a pledge to pay. In those situations, although the litigation was resolved, presumably those creditors are just unsecured. Being secured in full faith and credit is not being secured in anything in particular.
It's so interesting. We always think of revenue bonds as being less secure than something secured by the full faith and credit of the governmental body, and that.
There's academic literature to that effect. That one of the lessons of Detroit was people thought general obligations bonds were the most secure and revenue bonds were less secure because they're limited to revenue, I guess.
Right.
But the reality is, in a bankruptcy, it's really the reverse.
Interesting. So one of the things you said, and I forget which of the gentlemen said it, was that when I wrote down is the municipality can reject a contract. Is that, tell me, is that like any contract that they have? Can they reject it in the bankruptcy?
Any what we call executory contract, which generally means that there's performance due on each side of the contract. Okay. So like a note, if there's just a note, that's not rejectable.
Okay.
It's just a note, but the claim is what the claim is.
Okay. So, Mr. Ahrens, when you opened up your comments, you indicated that there was this threshold that the court looks at about, does this entity belong in bankruptcy, and were they otherwise operating in good faith? And I think this goes to some of the questions that Representative Martwick asked about. Is that a place where the court can say you're not taxing adequately, and so you're not otherwise operating in good faith? We're not even going to let you go into bankruptcy?
Well, that's interesting, and Bill has the experience at Harrisburg, so that might be more instructive. The insolvency prong, again, is the entity is not meeting its debts as they come due or not able to, and I suppose there's an element of taxation there. But again, got to be careful. Because of the federal system, the courts, the federal courts, and that includes the bankruptcy court, is not supposed to interfere with the property and administration of the municipality. So in general, as Bill said before, the courts stay away from issues of taxation, but it could be factored into the decision of whether the municipality is truly insolvent.
Was that part of the decision in Harrisburg, do you think?
Nancy, you were there more than I was there. Why don't you talk a little bit about Harrisburg?
Before we go to Harrisburg, I'm going to talk a little bit about Stockton. Again, Nancy Zelke, Senior Director with Alvarez and Marsal. Prior to joining A&M, I spent 20-some years as a city CFO in Kansas City. So, you never would think that moving forward, cities would be taking a look at bankruptcy as a tool, but it is a tool. But I'm going to go back to answer your question. In the state of Stockton, or in the case of Stockton, the city, as well as all the creditors, they looked at all available resources. So as the city kind of went through the AB 503 process, which was this pre-process, they looked at all available revenues.
But that's a California required process, right?
So as we moved into the case, so could the city, for example, could they take motor fuels tax funds and use those to fund operations? In that case, those motor fuels tax funds, those were restricted. They were restricted not only by the state law in California, but also how the city classified those. So in that case, those revenues could not be used necessarily to fund the day-to-day operations. At the same time, we also worked with the city hand in hand. We looked at some of for example, we looked within their parks fund. Did they have some monies that were gifted to the city? So in this case, we challenged the city. Is there an opportunity to go back to the original donor and to use those funds for other purposes? So cities who are in bankruptcy look at all available options before they actually do the filing, with that. The same thing in the city of Harrisburg. They looked at options as it related to potentially, monetizing assets. As they looked at that, they took a look at, parking revenues, parking lots.
And that was all pre-bankruptcy.
Pre-bankruptcy.
So before the government even goes into the bankruptcy, they, typically have totally exhausted, and that's part of the hearing process as information is presented to a bankruptcy judge, is the fact that the jurisdiction has, 4 tests. I think Brad's talked a little bit about that, but they have to show that they're budget insolvency, that the cash liquidity or cash insolvency, as well as the service insolvency. So a lot of pre-planning work goes into that.
And in the Harrisburg case, what happened was, again, you got to look at the state of Pennsylvania and the way that they handle this, and it's a thing called Act 47. So they went through an Act 47 process, a little different than the emergency manager process in Michigan. But reality was they didn't end up following what the Act 47 process said they were supposed to follow. Okay, they went in and said, it's kind of like you go to the doctor and I'm sick, so doc, give me a prescription. So the Act 47 process gave them a prescription, and they decided not to take the medicine. And so then they went out and got a single shingle lawyer and went in a bankruptcy court and just filed. And the judge basically said, well, you didn't finish doing what you started to do, so you got to go back, and we're not going to allow this process to go forward because you didn't do what you said you were going to do when you started this. And then once you go through that process, then we'll talk about it. And then it was ultimately dismissed.
It just seems in a political process and there's such an aversion to taxes that how do you make that part of the equation, because it should be part of good governance, but it doesn't always end up being part of the discussion on that. So then I just have one other question on the plan of adjustment at the back end that Mr. Ahrens, you spoke about. How does a court prioritize on the back end through the plan of adjustment between unsecured creditors or I guess how do they prioritize?
Okay, so again, in general, secured creditors would get paid in full if they're fully secured, and unsecured creditors would be either grouped all together in one class or separated into different classes. If they're separated into different classes and subject to the propriety of that separate classification, the different classes can get different treatment. Some might get cash, some might get notes, and the recoveries could be different in terms of the percentage recovery. You know, some might get 100%, some might get 90%, you know, but there are limits. So, for instance, you know, a judge is not generally supposed to approve a plan if different creditor classes get dramatically different treatment. Now, that is an issue that came up in Detroit, and the law is still evolving there. But general unsecured creditors, again, if they're in the same class, I should have said they're supposed to get the same treatment. If they're in different classes, then the relative treatment is supposed to be, you know, in line. So it's not like you can give one creditor 0 cents, another creditor 100 cents, but there is room in between to give somewhat different treatment. And then again, what that percentage, let's say all the unsecured creditors were in one class, so the simplest case, what's that treatment? Is it 50 cents in the dollar, 70 cents in the dollar, 20 cents in the dollar, 90 cents in the dollar? It all, again, depends on the resources of the municipality. And again, one of the things the judge will determine as part of potentially approving the plan is whether those creditors are getting all they can reasonably expect based on the city's resources. And that's a function, again, of assets and revenue and taxes and any other available resources. Again, the city has to look at all available choices.
Very good. All right. I think that's... I guess I should read some witness slips into the record. I have, these are, the only proponent I have is Rich Goldberg with the Office of Governor Bruce Rauner as a proponent, and then the opponents are Sakib Bhatti with the Roosevelt Institute, Andrew Bodavies with Fraternal Order of Police, Pat Devaney, Associated Firefighters, Dan Lichtenstein Boris, SEIU 73, Eddie Cruz, Associated Firefighters, Sean Smoot, Police Benevolent and Protective Association, and William Potts with SEIU Local 73. So with that, Representative Sandak, you want to
Thank you
call the next
very
panel?
much.
Thank you all very much. It was very, very helpful.
Appreciate all the commentary. Next panel, Larry Morrissey, Mayor of Rockford, and today's designated representative of the Illinois Municipal League, and Lawrence Massal from the Civic Federation, who, to some of the questions here, has a gatekeeper provision concept which is contained in Jim Spiato's materials. Lawrence Massal will give it more detail, but it's basically called the Local Government Protection Authority, which would be an in-between before a bankruptcy petition could be filed. Kind of think of it as a last resort. But I'll let these gentlemen speak to both instances. If you wouldn't mind introducing yourselves.
Certainly. Larry Morrissey, Mayor of the City of Rockford, honored to be able to be here and present testimony today.
Lawrence Massal. Lawrence Massal, President of the Civic Federation, a nonpartisan government research organization.
Thank you very much. Madam Chairman, members of the committee, it's an honor to be able to join you today to present testimony regarding the proposed enabling legislation that would support a municipal bankruptcy filing under Chapter 9 of the U.S. Bankruptcy Code. I also extend my appreciation to Representative Sandak for sponsoring this legislation. Today, as was said, I not only have the honor of representing the City of Rockford, where I've been mayor since 2005, but also the Illinois Municipal League, where I've served as vice president of their board and member of the board of directors since 2005 as well. So let me start with the disclaimer. I think it's very important to say for anybody who has bought bonds from the City of Rockford in the past, we don't plan on filing municipal bankruptcy, even if this bill passes. That being said, like many other cities in the state, and in particular many older urban communities like ours, we face escalating costs, a decreasing tax base, and the impending risk of an enormous state LGDF revenue cut. We face these growing financial risks while we must still manage our core responsibilities to our taxpayers to provide for public safety, public works, capital investment, and economic development, all while trying to do so at a reasonable cost. Against this backdrop, a managed reorganization and resetting through a Chapter 9 bankruptcy provides a much better solution than one that is disorganized and chaotic. Without an immediate change of course regarding state law covering municipal public safety pensions and facing the governor's proposed cuts to LGDF, there's a clear and present risk that many cities will be unable to meet all of their competing obligations as early as January 2016. When that occurs, we must seriously consider the best possible option for navigating the competing and mutually exclusive claims of pensioners, bondholders, current employees, and other outside creditors, We must ask the question whether we are collectively better off in state court or a federal bankruptcy court in the event that it becomes impossible to meet competing financial obligations and taxpayer imperatives. If history has proven anything in this state and in cities across the country, it's that delay, deferral, and denial are not solutions. We cannot avoid the indisputable financial facts of life any longer. History has also shown us that in the private sector and in other states that have allowed municipal bankruptcy, a managed reorganization can support an improved balance sheet, improved operations, while respecting all stakeholder interests, including those of our taxpayers. While I can't speak for every city, I can tell you that most communities like ours, we're doing our very best to balance these challenges, meeting our needs of our constituents while also managing costs and providing appropriate revenues through a reasonable system of taxation. Similarly, I'm not going to cast aspersions against past legislatures for doing what they thought was most prudent at the time. In the late 1990s, benefit enhancements began to occur that led to significant increases in unfunded pension liabilities. You'll recall that this was also a period in American history when, due to a vastly overvalued stock market, we thought we would retire the national debt, not just the deficit, the actual debt. Those who voted for those enhancements didn't anticipate the tech boom going bust then, nor did they foresee the housing market imploding in 2008. Our conversation today, therefore, in my opinion, should not be about pointing fingers at anybody. It shouldn't be about mistakes made in the past or wishing things were different than they actually are today. Our conversation, in fact, should be about providing a flexible approach to fix problems that exist right now and which may be very different in Rockford than they are in Carbondale, Joliet, or Hoffman Estates. In fact, even under the best circumstances, it's difficult to imagine state lawmakers being able to craft solutions that meet the needs of every single municipality. Every city is different. That's why we support a bankruptcy authorization where a federal bankruptcy court can fashion a city-specific remedy that fairly and appropriately meets the needs of all stakeholders. So let me tell you just a little bit about Rockford's story. As the third largest city in the state, we have the type of challenges that have befallen many older urban manufacturing communities. Unfortunately, we have one of the highest violent crime rates in the state, highest poverty rates, as well as one of the highest unemployment rates. These problems have been magnified significantly during the worst parts of the Great Recession. Nevertheless, we have worked hard to meet the needs of our citizens while managing costs. But despite our best efforts, we have one of the state's highest combined local property tax rates at 14% of equalized assessed value. That rate is high in part because we have paid our bills for the salaries, pensions, and benefits for police and fire protection and all of our other employees and other services we provide. While our combined public safety pensions were funded in the low 90s before benefit enhancements began, today our combined police and fire pension funds stand at 67% funded. That's a significant drop, but it puts us in the top 5 best funded of the 20 largest cities in the state. To sustain that level has not been easy. In fact, our city's combined fire and police pension contributions for 2015 will be over $12 million. That represents a 39% increase since 2009. That increase in costs has happened at the same time property values in our community have dropped by 30%. Consequently, our financial challenges have forced us to make structural cuts. We have, for example, been forced to permanently reduce budgeted staffing by 70 employees since 2009. And despite those cuts, we've seen our property tax rate rise because of the loss in values, as I mentioned. Even in years like the last 2 where we've not raised our levy at all, we've seen that rate go up because property values have gone down. We've also fought since 2009 to rebuild our reserves. It's been very difficult. But last year we finished with $15 million in cash on hand, which we continue to supplement with a $12 million line of credit. That combined amount of $27 million in available cash allows us to work through our bills and the ups and downs of revenue generation during the course of a given year. And while it's a respectable reserve, it does not meet our goal of 3 to 4 months of operating cash in reserve. Let me finally make some comments regarding the proposed cuts to LGDF. If those cuts are made as proposed, the net result would be an added burden on local governments, pressuring them to pass on those cost increases, those revenue decreases onto local property taxpayers in the form of drastic cuts in service or increases in local taxes. This is happening at the same time many have suggested additional caps on a local government's ability to raise property taxes. In Rockford, it's somewhat of a moot point because as the largest non-home rule community in the state, we're already virtually capped by existing tax cap rules. Also in Rockford, the proposed cuts to LGDF, that would amount to an immediate $7.5 million out of our budget annually. That represents approximately 7.7% of our city's general fund eligible for deficit allocation. That impact is even more concentrated, however, because we already deal with a minimum manning provision within our fire contract. Consequently, if the cuts are made to LGDF as proposed, the burden would shift disproportionately to police, public works, and other departments. Thus, a $3.1 million proposed deficit allocation to our police department actually would become a $4.8 million reduction. And that means to balance our budget, we'd be forced to cut approximately 40 police officers in a city with one of the highest violent crime rates in the state. So if LGDF is reduced at anywhere near the proposed amount, it would force devastating cuts to our police officers and our public works staff, or significant tax increases, which I simply cannot in good conscience recommend since we are already at such a high level of taxation. Local city councils throughout the state should not be put in the position of deciding at the end of the day whether to keep a police officer on the street or to pay a bond holder. And we can't continue to pass on unsustainable costs financed through an unsustainable and overburdened system of taxation. The alternative is a Chapter 9 reorganization. That's why I ask you to support House Bill 298. Simply put, if cities are put in a position where they can't pay all of their bills, this provision would provide the best way amongst not a lot of good choices, but the best way to help cities continue to provide public safety to citizens while protecting our ability to access the financial markets and provide fairness to all creditors. I appreciate the opportunity to present this information today, and I'll be happy to answer any questions.
Thank you. Thank you, Madam Chairman Neckritz, Representative Sandek, and all the members of the House Judiciary Committee that are with us today. I'm Lawrence Massal, the President of the Civic Federation, a nonpartisan government research organization that closely monitors the financial conditions of our state and our major local governments here in the Chicago region. The Civic Federation publishes comprehensive budget analysis for 8 local governments in the Chicago region and serves as a general resource for municipal finance issues throughout Illinois. We have seen many of our local governments in Illinois struggling to provide basic municipal services because they are overwhelmed by unsustainable pensions, rising personnel costs, and long-term debt obligations. Even relatively affluent municipalities have reported that over 100% of their property tax levy is now going to pay their pension funds, forcing them to find other revenue resources for basic municipal services. The state of Illinois has increased the burden on its local governments recently through delayed payments of local government assistance and the uncertainty of future funding levels. The state's financial crisis is also cited by the credit rating agencies as a major factor in recent municipal rating downgrades. The Civic Federation greatly appreciates the attention that this committee and this House bill and this subject matter hearing have brought to our distressed Illinois local governments. However, we do not think that direct filing for bankruptcy is the best answer forward for Illinois' distressed municipalities. Municipal bankruptcy comes with devastating and long-term economic and quality of life consequences for our municipalities. Bankruptcy requires costly, lengthy, and contentious litigation. It also will make it much more difficult for municipalities to access the credit markets. And communities that have experienced bankruptcy have reported a dramatic drop in the quality and response time of their municipal services. We do not see bankruptcy as the best way forward for distressed municipalities in Illinois, and instead the Civic Federation recommends the creation of a local government protection authority, staffed with financial experts that could assist distressed municipalities on a voluntary basis with the difficult decisions necessary to stabilize their finances. The Local Government Protection Authority is an opportunity for the state to help local governments it created and address many of the financial pressures that the state created and help them move back from the brink of bankruptcy. This proposal was developed by the Civic Federation's Pension Committee after seeing so many local governments struggling with the dramatically underfunded pensions and facing an array of unpopular and politically very difficult but necessary decisions. The Civic Federation sees an immediate need for an option that provides additional assistance to these municipalities before bankruptcy. The Local Government Protection Authority would make recommendations on what costs are affordable and sustainable and what essential services have to be provided and should not be interfered with. The authority would be staffed with the financial experts that could provide the local governments and their employees with a venue and an opportunity to identify creative and voluntary solutions. Many of our local governments are facing very similar problems, including unaffordable costs or liabilities, unbearable long-term obligations, excessive judgments, labor and post-employment benefits that have not been adequately funded. A state entity with expertise in addressing those issues could bring together the stakeholders to discuss available options and save our government from the pain and expense of bankruptcy. Under the proposal, the Local Government Protection Authority would consist of 9 members who would serve staggered 6-year terms. 4 appointed by the Illinois Municipal League, recognized as the leader of our local government interest. 1 appointed by the governor, and 1 appointed each by the House Speaker, the Senate President, the Minority Leader in the House, and the Minority Leader in the Senate. The goal of the Protection Authority would be to have all the participating municipalities fully fund essential government services and make sustainable contributions to pensions and OPEB by a specific day in order to maintain the credibility of these Illinois municipalities and access to the capital markets. When petitioned by a local government, so these local governments would have the option, if by their own accord, or if recommended by the Illinois Comptroller, one of their pension funds, or a creditor with a past due debt of $5 million, the authority would help the local government identify a reasonable path forward on the following issues. What government services are essential? What government services would need to be either looked at as put on or passed on to another unit of government? What sort of government service sharing could be established? What recommendations in terms of cost-cutting measures are essential to achieve the affordability of the government services? What potential tax increase is necessary and possible for this government? It would get to the core question, is this government in trouble because it has the inability to raise taxes or does not have the political will to raise taxes? Those are very difficult decisions made without the forum of an independent and objective arbiter. What interception of state revenues may be necessary to pay for required services of the government? What contribution increases are going to be necessary by the taxpayers, the public employer, and the employees? Is arbitration necessary? Should certain services, as I said, be consolidated or transferred to other governments? Could certain assets be privatized, sold, or leased? And finally, if at the end of all of this, whether the municipality should be authorized to file for bankruptcy and whether the municipality's plan of debt adjustment can be prepackaged or pre-negotiated. The Local Government Protection Authority would be funded by the state of Illinois as part of your annual budget process. The authority could also consider establishing a fee structure to help recover some of its costs. Other states have mechanisms for rescuing distressed municipalities. Most have evolved from the New York City Financial Control Board in 1975 and now include states such as our neighboring Ohio, which has a Financial Planning and Supervision Commission that steps in to assist the distressed municipalities. Michigan, which was talked about in the earlier panel, has a Local Stability and Choice Act. Indiana, which allows its distressed political subdivisions appeal board to appoint an emergency manager for distressed subdivisions. Pennsylvania, which was also talked about, the Financial Distressed Municipalities Act, which allows the state to appoint a coordinator to guide the municipality in getting its financial affairs in order. California's Neutral Evaluator legislation, which was recently passed to provide a period of objective and dedicated negotiation and resolution of issues affecting major creditors or financial problems. North Carolina is the North Carolina Local Government Finance Commission is the oldest in the nation. and it grew out of the problems that North Carolina experienced in the Great Depression with so many defaults. And as a result, in North Carolina, no local government can issue debt without the involvement of the state and without the state's participation in advice going forward. Jim Spiato, as has been mentioned, who is a chairman of the Civic Federation's Pension Committee, submitted written testimony, which I would commend to all of you to take a look at. It provides much more background and much more detail about our proposal. It's clear from Jim's testimony and what we have seen going on in terms of evaluating the condition of our local governments that a local government protection authority could help municipalities avoid lengthy, costly, and often counterproductive litigation over payment issues. Illinois local governments are facing unprecedented and widespread fiscal crises, but municipal bankruptcy is not alone the answer. The state created these units of local government and has the ability and the opportunity to help the municipalities before pushing them further to the brink. We encourage this committee to consider the creation of a local government protection authority as an alternative or as a first step prior to allowing for bankruptcy filing, as could potentially be an amendment to House Bill 298. Thank you for the opportunity. I would be happy to answer any questions.
And as Mr. Masal said, I did get language from the Civic Federation with respect to a potential amendment that would have this intermediary step thereon. Jim Spiato, who's a rather well-known bankruptcy attorney in Chicago and has had a pretty extensive experience in several Chapter 9 filings too, submitted written testimony, and within that testimony is the Civic Federation's proposal, albeit truncated, with respect to an intermediary step. Larry, can I ask you if IML, I don't know if they've taken a position on the intermediary step prior to access to Article 9?
I believe we are supportive of that step. I haven't had a chance to see all the details and appreciate hearing some of it explained today. But generally speaking, we'd be supportive of it. And I think one of the hardships that we've had in the current state of affairs is there's not a lot of guidance. And we even have heard the Better Government Association wrote an article late last year, I think it was, or early this year, talking about 2 cities in Illinois that kind of just flew under the radar and filed without the state's permission to file, but a bankruptcy judge apparently allowed it. So I think right now we are in a period where there's not much legislative guidance, and I think that would be appreciated. And we would certainly, speaking just on behalf of our city, appreciate that opportunity as sort of a preliminary step prior to a filing.
And Lawrence, before I pass it on to my colleagues for any questions, is the Federation, did they take a position with respect to having this gatekeeper provision installed as an amendment? Would you otherwise be then supportive of allowing, once municipalities and other locals and units of government went through a gatekeeper analysis, and if it didn't work,
right? That's part of
then you would be supportive of permitting those entities of local government to file Article 9 actions?
Yes.
Thank you.
Representative Anderson.
Thank you for clarifying that first off. So you view this, if you will, as the explained gatekeeper function. Is that correct?
We view this as the state taking the responsibility to evaluate in a coordinated way, which in helping municipalities avoiding bankruptcy. The Civic Federation does not think bankruptcy is the best answer. We believe there are interim steps, there are things the state can do to help them. But there are municipalities in the state of Illinois operating right now that are insolvent, right? They're incurring more obligation than they have the ability to pay, and the state is not doing anything. But the state merely collects. The only authority that we'll be able to identify is the state comptroller is required to collect the certified audited financial statement, or to collect them, but no one evaluates them to see what the condition of those governments are. It is a very unclear and non-transparent process for what governments can do. And what happens if a government doesn't? As many of the southeastern suburbs of Cook County, there are significant governments that don't provide their CAFR. There is no, according to the comptroller, they have no authority to force the submission or to even consolidate or to make demands as to what form those reports should be in.
All right, I appreciate your concerns about transparency, and I agree with those. Transparency is something we all work towards. But I just want to understand your proposal. At the end of the day, if we adopt an amendment that reflects your recommendation, and an entity, a municipal entity, goes through that process, and the determination is that it doesn't work, you are supportive of bankruptcy in those situations.
If that is the recommendation of the Municipal Protection Act Authority, and after they have reviewed it, if they have weighed all the different options, yes, that is the one path for the end of that government.
Thank you. Now, I am concerned about the assumptions that your proposal makes, and the assumption that I'm hearing in that proposal is that municipalities really don't know how to manage their money. And I challenge that assumption pretty strongly. And well, let me finish. The reason that I hear that is because you talk about these experts coming in and explaining to municipalities, coming on down to the farm and telling them that this is how they ought to do it. These are essential services and these aren't. And I challenge that assumption. The reality is that local government are the people who actually know how to manage their money. They are the entities that have to be solvent, generally speaking. There are always exceptions, but in the communities of the state of Illinois, I am proud to represent local governments that struggle every day, just like Rockford talked about, that struggle every day to manage their money and do those essential services. You're asking the state to come in and advise them? I challenge you that the state is the one who could learn a lesson from the local municipalities about how to manage money. It's not fair or appropriate to suggest that. The reason our municipalities are struggling right now—
Could I respond to the assumption?
No, not yet. Not yet. The reason that we're struggling, our local communities are struggling, is because, number one, unfunded mandates. Number two, property tax caps. You're building them up from the bottom with expenses that they cannot possibly afford, and then you're limiting their ability to generate revenues. By the way, I'm not advocating for increased revenues, but I am advocating for relief as to those mandates. Those are the problems that are creating this situation. It is not mismanagement by local governments. And I'm also concerned, you talked about funding for this. The state is broke. We're going to add more expense?
So, responding to your first, the Civic Federation does not make the assumption that local governments can't manage, that they don't have financial expertise. They're overwhelmed by the actions taken by this legislature that basically pushes down on them their bad practices, right? When you add benefits that they didn't support, that they weren't for, and you expand the pension benefits and you increase them, but you don't provide any mechanism for how they're going to pay for them, right? They're in an untenable position. You said two different things. You said it's the mandates that are creating the problem, but you're not in support of funding the mandates because the state is broke.
Correct.
And
because in favor of relieving the mandates.
That would be very effective. I just want to clear the record. So the government's, right, the purpose of the Municipal Protection Act is to provide a place where it can be sorted out objectively. Do they have the ability to raise the taxes necessary to fulfill the mandates that you have established at the state for them? Things like staffing requirements that were passed last year in the midst of the state's financial crisis, in the midst of your knowledge of the local governments, we decided to dictate to them what the level of staffing would be on their fire trucks. And with no residual mechanism for them except to cut their other staff areas in order to fund them. So yes, the Civic Federation believes there needs to be a better way for those governments that are in trouble. It's not all governments, so all the governments that are basically doing well financially, those that are continuing to maintain their pension funding, those that are able to meet all their other core requirements, they would not seek participation in the Municipal Protection Act. But those local governments that say we can't meet the demands that Springfield has put on us, that our negotiations with our employee groups in terms of what they're demanding, we need some help. We need some financial expertise.
And so the objectivity is what you're looking for? You think that local municipalities don't have that objectivity?
I think everybody benefits from having a referee from when they present their facts and then someone can say, these are the facts. You're entitled to your opinion. You're not entitled to your own facts. It is a quasi-judicial decision that says, in order to get to the point where everybody sacrifices, because that's what we're facing in these governments that are funding, everyone is going to have to sacrifice. The answer isn't going to come just from one group winning and the other group losing. It's going to be more taxes, less services, and in order for these governments to go forward.
If I can, the reason why I support it personally is that it's a chance to bring all the stakeholders to the table and look at that objective lens through another set of eyes. And I'll just give you a quick example of how we sort of replicated that in 2009 when the bottom fell out and we were facing huge immediate revenue decline without a commensurate decline in our costs, right? So we still had to pay our pension costs, still to pay to keep police and fire in the streets. I appointed a budget advisory group made of individuals, leaders with financial backgrounds in the community. We opened the meetings to the public, and we invited our collective bargaining groups to present. And it was, I can't tell you that we got everything we wanted from a management and administration side, but what was really valuable was trying to get the community, the bargaining groups, and our staff and the other stakeholders on the same page, looking at the same information. That was very valuable, being able to get the local news media to be in the room and get educated, because historically the intricacies of a collective bargaining agreement probably aren't understood by some council members, let alone members of the general public. They're sophisticated documents. They've got a lot embedded in them. There's a lot of things that people may not understand. So the process of going through this sort of a gatekeeper process is one that I would support, because I think I don't want to file if I don't have to. I don't think any mayor would want to. That process hopefully will help align things, and we may get some voluntary movement prior to that need to actually have a judge come in and be the arbiter. The other thing I would just say that's somewhat embedded maybe in all of our remarks is that there are definitely things that could be done on a legislative basis to reduce unfunded mandates, to deal with pension problems. Again, I'm not saying who's to blame, but the reality of the mathematics is something you can't deny. And as trustees of a pension, I get letters from our pension fund trustees all the time saying, you got to make your payment. Where are your assumptions on your rate of return and all those other things that they're obligated to do? And I understand that role. I've got a role to keep current employees employed. So there's these tensions that exist, and I think going through a process where, even like we are right now, just having this conversation, I think hopefully will be beneficial for the legislature and all the stakeholders to say, hey, this is serious. If we deal with some of the underlying legislative issues, hopefully that relieves some pressure, and the bankruptcy issue is less of an imperative for a lot of cities. For some cities, they are already insolvent. I don't believe ours is, and I believe there's things that we have to deal with that if handled on the legislative side, we don't get to where the city of Rockford would ever have to file. But I want to be prepared. That's my job, to look over the horizon. And frankly, no offense to anybody in the room, but I can't count on something getting done when it hasn't gotten done last year or the year before. And if this is, if we have no other choice, I don't want to go through the chaos and disorganized process of having, like I said, deciding who to pay. I'd rather have a process that's more organized. And the two-step process, I think, is one that would be helpful.
Thank you, and I appreciate both of your comments about it. And I'm not opposed to the concept of the gatekeeper. In fact, I think that's probably a pretty advisable thing. I am concerned about the level of this proposed local government protection authority. It just seems to me like we're creating another layer of government, and that does concern me. Thank you both, though.
Thank you.
Representative Martwick, followed by Representative Breen.
Thank you, and thank you again for coming. I love the city of Rockford. It's a good city. I've got some friends there, and I've visited, and I give you credit for the good work that you're doing there. I also want to echo Representative Anderson's sentiments about the local governments are the ones that are doing the good work and the responsible work. So I give you credit for dealing with, I know that you have some difficult financial times there in Rockford. You had mentioned that you have a real distaste for the possibility of filing Chapter 9 bankruptcy. And I would understand that. I, like you, served in a much smaller municipality, but I served on that municipality during some very escalating financial difficulties. And we went through a very, very difficult process, making very austere cuts to our government, but also raising revenues to make sure that we could meet our obligations, including to our pension funds. I want to double back on what you had mentioned. What do you know what the proposed LGDF cuts to Rockford are going to mean to you?
So the proposed cut of 50% to LGDF would be about a $7.5 million. We get about $15 million a year in LGDF funds, so half that would be $7.5 million.
Mm-hmm. And then, of course, that would make your situation, which is already precarious, substantially more so.
That's an understatement, yes. It would make it very difficult. I would argue that we have already cut in cities like Rockford everywhere we can.
Yeah.
And so additional cuts would be, would be very, very difficult to try to absorb without impacting, I wrote the word down, service level insolvency versus financial insolvency.
Right.
So you can cut your way to make the math work, but then you're not delivering the services that you need to your city. So it's a tough balancing act.
I understand what that cutting to the bone is like. As I said, we went through that ourselves. I'm sorry, could you, Mr. Masal, could you repeat where would this authority that you were talking about, this gatekeeper authority, who would be on this? Who would serve on this?
So, and this was our suggestion, certainly open to whatever balance. The idea was that it would be a state authority appointed 4 members by the Illinois Municipal League, 1 by the governor, 1 by the Speaker of the House, 1 by the President of the Senate, 1 by the minority leader in the House and the Senate. Just basically giving you, a broad representation of the major General Assembly, the governor, and the Municipal League. And there could be others. There are other models in other states in terms of some states use the director of the Department of Commerce and the director of Revenue. But the idea being is to get an objective authority that with expertise, especially with the municipal league representation, that understands the issues affecting local government.
And the idea would be to right the ship before the bankruptcy filing.
Exactly,
Okay.
exactly.
And including, as you mentioned, maybe overcoming the political or the failure in the political will to raise revenues where revenues are available. I get it. Sometimes you're tapped and there's no more to go, but if there is room, you would address that situation in that, or that would be the function of it. Is that correct?
Because, again, the Civic Federation is very strongly that bankruptcy is a very dangerous place for us to be heading without looking at every possible chance. And yes, we have great respect for the local governments, but they are being pressed in a way that is unprecedented financially and otherwise. And so the state created these local governments. The state created most of the problems financially that these local governments face. So the state has a role, and in other states they've seen great reduction in the number of bankruptcies. When you compare the number of bankruptcy filings in states that have an intercept or a authority that basically requires a process going forward, there are much less bankruptcies in those states.
Good. Well, and I know that we're talking about the nuts and bolts of the bankruptcy, but inevitably policy plays into effect here. And I look at the situation that Rockford is in, and I see a state where we have currently, I believe, somewhere around the 40th, or number 40 in terms of our state tax rate. We refuse to address revenue issues. We cut so in order to keep our tax rate exceptionally low in this state, we take the money away from the local governments. We make them go to their tax rate, to their local property taxpayers, which causes the exceptionally high taxes, real estate taxes, that you, Mr. Mayor, have suggested, and creates an incredible financial burden on these and an inability to make ends meet. So I really feel that a lot of these problems, if you want to figure out how to avoid Chapter 9 bankruptcy on the municipality level, maybe it's time we start addressing our lack of political will to address revenue in the state of Illinois. And that would certainly secure the financials of many of our local governments. Thank you.
Representative Breen.
Thank you, Madam Chairman. Just wanted to direct a couple questions to you, Mr. Masala, this morning. I heard in your recitation of your proposal that there was possibly an option for creditors with past due balances of over $5 million to force a municipality into this particular arrangement?
Well, to make the petition that the authority should consider, that the government should consider going into the Illinois Municipal Protection Authority.
Okay, so I mean, they could actually, so an outside creditor
Right.
could actually then force a municipality into this.
Right.
Okay. Now, what options are there at the this new municipal authority, this protection authority that you're proposing? Can they force a municipality then to take certain actions?
They
Or
would
is it merely
no. They would basically
advisory?
have the ability to work with that municipality and develop a plan, a financial plan going forward, a series of recommendations, whether it's cutting various services, whether it's raising taxes. You would have the benefit of an independent. You talk about the lack of political will. Everyone is always looking for an excuse to basically justify what hard action that they're going to need to take. And so having a state authority saying you have to raise your taxes or you have the ability, that's, if nothing else, one of the benefits would be to confront the issue, does this government have the ability to raise the taxes that would be necessary to fund this liability going forward? And if the legislature sought after a plan was approved by the authority, the legislature would have the Illinois General Assembly would have the opportunity to put it into force of law by enacting that recommendation and establishing that. Or if it did nothing, then it would be merely a recommendation of the authority to that government, and it would be up to that government to decide going forward. I think the key thing to recognize is that authority is going to make a series of recommendations that are going to be painful and hard things to do, and that they're going to be aimed at, basically, if it's a plan, to get that government to do that to avoid bankruptcy. If that government is not able to do it, is not able to fulfill the plan, chooses not to fulfill the plan, it's still in the same spot. It's still basically, that doesn't mean it has approval to file for bankruptcy unless they go directly to the General Assembly and you approve their filing for bankruptcy. Under this proposed amendment and the proposed format, the Illinois Municipal Protection Authority would have the power to grant or to recommend filing for bankruptcy, and then they could go forward. But if they're just making recommendations on a plan for going forward to avoid bankruptcy, then they're not. Then if the municipality is not able to carry it out, if the state does not decide to give it the force of law, then they're in the same spot before they started.
Okay, just so I'm clear, though, then some aspect of this plan is a recommendation to the General Assembly, or a recommendation to the local body, but then a recommendation to the General Assembly, which we could then adopt and force on the local municipality, or force them into bankruptcy, or we would approve their bankruptcy.
You could not force them into bankruptcy, but you would, if they decide not to go forward and they find themselves in a place where they want to petition directly for bankruptcy, then they would be back to petitioning you or the authority for bankruptcy.
Okay, so the authority, or at least as recommended, the authority would actually then be able to we would empower the authority with the ability to approve the bankruptcy filing of a municipality.
Yes.
But we could also do it ourselves directly for that municipality. I'm wondering, when we're talking about the drivers of municipal bankruptcy or the need for it, it seems to me there are two different types of costs that are being imposed there. One is pension related and one is non-pension related in terms of making this. So we talked about the mandates coming up from the bottom, property tax caps or what have you from the top. Is that an accurate statement? So there's pension, there's non-pension.
I guess I'm not really understanding the distinction because, without a doubt, pension liability in Illinois, right? Because the state legislature, especially in some of those municipalities where the state legislature created separate pension funds and basically dictates both the benefits and the funding mechanism, is what's driving the cost in particular. I mean, for those governments, that is most governments. Their largest liability is their pension situation. Others have considerable debt as well, and so they fall into the same category. So.
Okay, I guess one reason I ask is because as I look at the way life works here with our constitutional provisions, the General Assembly can remove mandates that can drive up costs that are non-pension. We have less ability to deal with pension, certainly pension benefits already accrued, and that we're about to hear from the Supreme Court about what our powers are. But on the non-pension side, is part of what your entity would do, could they recommend lifting of certain mandates on that particular municipality or other ways to help them reduce the costs of of doing government business in Illinois? Since these plans are being recommended to us and we're enacting it anyway, we could actually change law for that particular area.
Yeah, I guess they could, but I think that the construct that we had imagined was they would be making recommendations based on what the municipality can do under existing law, right? And so, changing other mandates that apply to all units of government, I think it goes to, as the mayor said, the confidence level of anybody you telling them to go to Springfield to get that fixed is low. I mean, in terms of how long that would take and whether that's inactionable.
Just to follow up on that, I'm not a constitutional lawyer. I'm a recovering lawyer, however, used to practice. But the legislature, I don't believe, can delegate out its authority to, on a case-by-case basis, to this body to change the law, whether it's a Manning provision or anything else. I think there could be voluntary agreements that get done, but short of that, that's when from the gatekeeper standpoint, if you're doing what has been recommended, you still can't get your deal done, and the gatekeeper gives authority to file, then it's when a bankruptcy judge would be empowered based on existing case precedent and the supremacy clause, I believe, to enact various, to do things that otherwise couldn't be done.
Sure. And again, to that point, Mayor Morrissey, I look at, for instance, with this latest, at least doing my back of the envelope calculations, folks in Rockford made back $46.4 million or so in income tax that's now back in their pockets. And you're going to get a $7.5 million cut if this LGDF cut as proposed goes through. If you were able to be relieved of certain mandates as part of a plan of trying to fix the problems and get yourself back to solvent, and again, we're using Rockford as an example, right, not just for this purpose, it would seem to me that again, this plan is being recommended to the General Assembly. We are the legislative power of the state of Illinois. We could relieve mandates in individual instances like this, particularly to keep folks out of a bankruptcy court, it would seem, or at least it's possible. So I may urge that be looked at in terms of the local control, in terms of being able to empower local areas to make these changes. And again, so you can make up that $7.5 million. And I'm the guy that I represent the other 3 communities in Illinois that have rejected home rule, and along with Rockford, which seemed like a wonderful idea at the time and may seem less wonderful now.
I was in high school, so I don't remember it exactly. I think maybe junior high, but just maybe if I could just respond a little bit. I had a chance to speak with Governor Rauner recently, and when he's talked about empowering local communities, I certainly would support that, and it's something that the IML has been supportive of for many years. However, at the same time, talking about cuts, my fear, just being in Illinois for a number of years in government, is that we'd get the cuts as one part of the package, but no reforms and on the empowerment on the other side of the package, which then we start talking about Chapter 9, because you can't have it both ways. And there's a lot of different ways to make the math work. We've done calculations on what if we just had the Chicago level of benefits for police and fire downstate, what that would do for savings for us, because of the significances on COLA, significances on retirement, differences on retirement age, things like that. Some of them, there's a lot of different things that you could do to creatively try to manage, but we're like playing a game of cards where the rules are changing, and it's a challenge. I have great respect for our financial professionals within our organization, and I know I can speak on behalf of many cities throughout the state that take these issues very seriously. But again, there comes a point where you've got cities that may need the actual financial help because they're not as sophisticated, they don't have those resources, or they need a venue to bring other folks to the table. And that's why I think having something like the Local Government Protection Authority, if done appropriately, can be helpful to prevent an unnecessary bankruptcy. I would say bankruptcy for us is definitely not necessary, definitely not right now. But my job as a leader, again, to look over the horizon, be aware of the context that we're dealing with, and say, if all else fails, we need to have a situation that we're not, what we don't want to have happen is no law on the books. January hits, right? We all know what happens in January 2016. If nothing else, the law goes into effect based on our last attempt at pension reform, which I appreciate all the support on for new hires. But the package now requires, I believe in January, that the state will be authorized to start diverting funds away from general revenues into the trustees, into the pension trusts. If that occurs, I know certain cities, they just won't have any money. We have 3 cities around Rockford where they're not only not home rule, they don't levy a current property tax at all. Loves Park, McChesney Park are 2 of the 3. And they have significant needs and costs. So when that starts to happen in January, if nothing else happens between now and then, you're going to have those issues where somebody's not going to get paid, and it's going to be a mess if we don't have some level of clarity in legislation that's done between now and then.
All right. Thank you, gentlemen.
Thank you very much.
Thank you.
While we wait for the next panel, if Pat and Andrew want to step up, just for clarification, the proposal of the Civic Federation, it ain't soup, obviously, and it's not even an amendment yet. This is all subject matter anyway. But the concept of a gatekeeper provision, whether it's mediation-based only, and frankly, I'm not too big on state mandates in that step either. So it would be something I'd circulate as last chance before the ultimate concept of a Chapter 9 is filed. So that's food for thought. Obviously, gentlemen, you both slipped in, right? Right. Thank you. Feel free.
Thank you, Madam Chairman, and thank you, Representative Sandek, for beginning this conversation regarding municipal finances. Obviously, it's an issue very important to me. My name's Pat Devaney. I'm the president of the Associated Firefighters.